would be the closest example I can give. The last very brief one would be compensation. It was submitted before Your Excellencies that the applicants provides no statistic as to the size of Agiva, the resources in Agiva, and the geographical location of Agiva. That simply cannot be a basis to ask for $1 billion as a matter of compensation. The practice of the court has been that a separate hearing shall be ordered for determination of exact amount of compensation, and the mere assertion.
It is not the quantum, but in principle, the availability of compensation. You are not saying that they are not entitled to compensation. They are, but you are only saying that 1 billion is too much.
Absolutely, Your Excellencies. We accept the compensation is possible to be awarded under the jurisdiction of the court, of course, the Corfu Channel case. However, it would be disputed on the quantum, exact quantum, and the arbitrary naming of $1 billion as the amount.
All right.
If I may not have further assistance, I shall pass the case on to my co-agent.
Thank you very much.
Much obliged.
Please give us 1 minute. Remain seated, please. We will let you know when we are ready. Yes. Yes.
May it please the court, I will now continue the case of the respondent. I first start with the second declaration, that is regarding the apprehension, abduction and trial of Ms. Tbilisi. First, the respondent feels pertinent to note a fundamental mistake made by the applicant, that is, a confusion between adjudicative jurisdiction and enforcement jurisdiction. The applicant has mentioned the applicability of the protective principle and passive personality principles of jurisdiction. In fact, the respondent accepts that these jurisdictions apply on adjudicative side, but the issue today here is enforcement jurisdiction. And of course, as Your Excellencies will be extremely familiar, that the first fundamental rule, as pronounced by the Lotus case, is that any enforcement jurisdiction must be subject to territorial sovereignty. Here it is submitted that the arrest was arbitrary. Of course, the applicant's argument on the abductors of Ms. Tbilisi.
When Ms. Tbilisi made the statement she did, she must have known she was contravening Namibian law. Must have known. If she knew that, then she took a risk in making that statement by contravening the law of a country.
Certainly not, Your Excellency.
Why not?
If we make a remark, for example, in Malaysia, how will we know, for example, in Congo, that this would contravene any kind of laws in Congo?
The analogy is not quite appropriate, isn't it? Malaysia and Congo is not at war previously, and whereas Donoville and Bergen are not at war. I mean, my learned chief judge question was about the indiscretion of Ms. Tbilisi.
Understandably, Your Excellency.
So she ran the risk. She walked into this with her eyes wide open.
Even if there was a risk, Your Excellency, this does not entitle such an abduction.
Suppose we take the fictional country called Malaysia. All right, we will take this fictional country called Malaysia. We'll call it Malaysia, all right?
Certainly.
And suppose Malaysia has another neighbor, another fictional country called Singapore. We call it Singapore. And suppose by the law of Singapore, it is an offense to say anything against a fictional person called Lee Kuan Yew. Right? Now suppose a Malaysian journalist writes and says that, what are the words used here? He's a buffoon. Lee Kuan Yew is a buffoon. and Lee Kuan Yew doesn't take this person, this non-existent person called Lee Kuan Yew doesn't take this personally. I mean, takes it very personally. And some members of the Singapore security forces enter Malaysia and take away this journalist and try him or her in this fictional country called Singapore. Do you think that's all right?
Of course not, Your Excellency. The issue here is not risk. Whether there was risk or not is entirely irrelevant. The issue is whether there was consent by the fictional country of Malaysia or Singapore to let Singaporean forces to enter to Malaysia to abduct that person and to be tried in front of Singaporean courts.
But by the domestic law of Singapore, settled by authority, let us say, by their court of appeal, that it does not matter how a person is brought before the court, so long as he is before the court, and the court assumes jurisdiction, then that will be an internal matter over which this court can have no jurisdiction.
That is another matter, that is exercise of adjudicative jurisdiction. And that is why the respondent at the very beginning of the submission emphasized enforcement jurisdiction, which is really the crux of the issue today.
That's where you have fallen into error, isn't it so? Because you should be addressing adjudicatively.
Both jurisdictions will be addressed. And of course, this goes to the principle of mali captus benetentus, whether it stands. But going back first to the issue of enforcement jurisdiction, here there was no evidence that Donovan domestic laws provided for extraterritorial application of its criminal laws.
Now, can I just intervene and ask you this? There was a gentleman sitting in a hotel in Karachi, minding his own business, when two U.S. members of two United States members of their security service, Secret Service, walked into his room, barged into his room, kidnapped him from Karachi, put him on a plane, took him across to the United States and tried him. United States court, district court, the federal district court, New York, assumed jurisdiction. He was convicted and he's now serving 20 years in a federal penitentiary. Do you think that was all right?
Was it a violation of international law, and was it successful? And to continue my learned Chief Judge question, can Pakistan bring it to the International Court of Justice?
There are two relevant issues here. First is the issue of arbitrary arrest, which is a separate issue before exercise of jurisdiction. And this is in fact a question that the applicants have failed to answer. That is, even if individual human rights were violated in arbitrary arrest, they could, of course, the state on behalf of that person could bring a separate claim of a violation of that individual right. But the exercise of domestic adjudicative jurisdiction will be another matter, which rests upon the principle whether mali captus benetentus stands.
So is the conviction of that Pakistani gentleman good or bad?
Of course, according to United States law, it might be good.
And according to their law, this is good.
However, according to international law, that is not good.
Why do you say that?
Because the principle of mali captus benetentus no longer stands. The principle is really mali captus maletentus. In fact, the only case cited by the applicant is the Icon case, and the Excellencies have very quickly dealt with that case. It was, of course, a very renowned case of a lawful exercise of this arrest and jurisdiction. But in fact, there are numerous counterexamples that represent evidence of customary international law that justify mali captus maletentus. For example,
but if it was a case of kidnapping, isn't it a matter of a complaint of the individual concerned, not the state matter?
as I've previously submitted, there are two possible claims. First is individual violation of the human rights of that abducted person, and of course the state by principle of diplomatic